A very good morning to everyone present here. I, Sanjana Rao, on behalf of the Gender Studies Committee, warmly welcome Honorable Mr. Justice Ashok B. Hinchingiri, Chairman, Karnataka Law Commission, Bangalore. Dr. C.S. Patil, Chairman, Karnataka Institute of Law and Parliamentary Reforms. Dr. V. Varadaraj, Director, ESIS Medical Services. Professor S.V. Joga Rao, Founder, Lexil Excel Attorneys. Dr. Jaidevan S. Nair, Dean, School of Law, Christ Deemed to be University. Dr. Sapna S., Associate Dean and Head of Department, School of Law, Christ Deemed to be University. Dr. Valarmati R., Professor, School of Law, Christ Deemed to be University. Dr. Chaitra R.B., Assistant Professor, School of Law, Christ Deemed to be University, as well as all our other speakers, guests and participants. To begin and on an auspicious note, we would be beginning with the ceremonious lighting of the lamp, seeking the guidance and blessings of the Almighty in all our endeavors. We invite our dignitaries, Honorable Mr. Justice Ashok B. Hinchingiri, Dr. C.S. Patil, Dr. V. Varadaraj, Professor S.V. Joga Rao, Dr. Jaidevan S. Nair, Dr. Sapna S., Dr. Valarmati R., and Dr. Chaitra R.B. for the same. We also invite Bhavna Hegde to sing the invocation song.
Mahaganapatim manasa smarami Mahaganapatim manasa smarami Mahaganapatim manasa smarami Vasishtavamadevaadivandita Mahaganapatim Mahadevasutam Kuruguhanutam Marakoti Prakasham Shantam Mahakavyanatakaadipriyam Mahakavyanatakaadipriyam Moshikavahanamodakapriyam Mahakavyanatakaadipriyam Moshikavahanamodakapriyam Mahaganapatim manasa smarami Vasishtavamadevaadivandita Mahaganapatim
We would be remiss in our duty if we did not introduce our esteemed collaborators for today. The Karnataka Institute for Law and Parliamentary Reform was established under the Department of Law, Justice, Human Rights and Legislation in the Government of Karnataka in the year 2005. The objectives of the institution are to develop an advanced forum for reform of law and parliamentary practices, to undertake research in myriad dimensions of law and suggest law reforms, promote research, draft new legislations, play a vital role in bringing about legal awareness and awareness of parliamentary procedures and practices, organize conferences and seminars, undertake publication of research works and similar activities. In pursuance of the objectives, the Institute has published 85 books based on research, conducted more than 300 seminars on socially relevant law topics in collaboration with universities, organized model legislative assemblies for the benefit of students at zonal and state levels, exclusive model legislative assembly for lady students training for government advocates and prosecutors. Today's conference focuses on the transformation of policies that propose reproductive rights and the social complexes therein. To address the same, the conference has 6 themes under which papers will be presented. Medical termination of pregnancy and reproductive rights, surrogacy laws and the right of surrogate mothers, legal challenges in artificial reproduction, LGBTQIA+ and parenthood and assisted reproductive technologies, consent and bodily autonomy in reproductive health care, and reproductive health and workplace rights. For the conference, we received a grand total of 150 submissions across the 6 themes from students, academicians, and practitioners from across the country. Ultimately, 85 abstracts were shortlisted with 80 full papers collected for the conference. Presenters today are present on venue and are turning in online for the same as well. I now invite our faculty coordinator, Professor Dr. Vallarmati R., to give the welcome address.
Good morning, distinguished guests, respected resource persons and dear participants. It's with great pleasure and immense pride that I welcome you all to the National Conference on Reproductive Rights and Policy Transformation in collaboration with Karnataka Institute for Law and Parliamentary Reform, Kilpar, Bangalore. First, I would like to welcome our today's chief guest, Honorable Mr. Justice Ashok Bangairappa Inchagiri. Sir was born on 24/8/1955 at Haveri. Sir completed his MA in Political Science from Jawaharlal Nehru University, New Delhi, and LLB from Bangalore University. Sir enrolled as an advocate during 1987, practiced in the lower courts and high courts at Karnataka, and Sir was appointed as additional judge of Karnataka High Court on 7/3/2005 and permanent judge on 1/3/2007. Retired as High Court judge on 23/8/2017. Sir has worked as chairman of the Juvenile Justice Committee constituted to take care of the children in need of protection or children who are in conflict of law. Sir has worked as governor on the board of Karnataka Judicial Parade. Sir was honored with the Great Son of Soil Award for the outstanding services, achievements and contribution conferred by All India Conference of Intellectuals and presented by Honorable Dr. Justice Dalveer Bhandari Judge, International Court of Justice. Karnataka State Law University Hubballi has conferred honorary doctorate degree for Sir, Doctor of Laws LLD honoris causa at its 6th annual convocation held on 29th November 2024. Sir was appointed as a chairman of Law Commission of Karnataka by the Government of Karnataka. Sir assumed the charge on 30/10/2024. Sir, I on behalf of Christ University School of Law welcome you to this national conference. Now I would like to welcome our today's guest of honor, Professor Dr. S.V. Jogarao, who is the founder of Legal Excel Attorneys, formerly it was called as Legal Excel, a law firm of advocates, solicitors and healthcare consultants. Sir completed his LLM at Andhra University, followed by MPhil program from the National Law School of India University, NLSI Bangalore, and a PhD from Andhra University. Sir founded the firm in the year 2001. Person to completing more than a decade was the founding faculty member of NLSI Bangalore. He gave up his full-time teaching position and commenced professional legal practice as an advocate and solicitor. Sir provides an array of legal services including litigation, consultation, medico-legal audit for hospitals, doctors, patient groups, health insurance, and third-party administrator entities, health technology companies, diagnostic labs, and several technology-driven healthcare startups. Sir has an extensive experience spanning 2 decades in the domain of healthcare law and ethics. Sir focuses on medical negligence, liability of doctors, nurses, and medical establishments, surrogacy, and alternative reproductive techniques. Sir, on behalf of KILPA, Christ University School of Law, I welcome you to this national conference. It's my privilege to welcome the President of today's national conference, Director, KILPA, ex-official member, Karnataka State Law Commission, Professor Dr. Chidananda Reddy S. Patil. Sir graduated from University of Mysore in 1983 and Sir moved to Dharwad to pursue studies in law at the University College of Law. He completed his LLB in 1986 and Sir obtained master's degree in law from University of Mysore in 1988, specializing in constitutional law. Sir secured first class and first rank at LLM, for which he was awarded 2 gold medals and a cash award by the University of Mysore. In addition, the government of Karnataka has awarded him a cash prize for securing the first rank in LLM, and he holds a doctorate in law from the Karnataka University, Dharwad. Sir has taught law for over 3 decades at Jesus Law College, Mysore, HA Law College, Dharwad, KLE Law College, Bangalore, University Law College, Dharwad, and KSLU Law School, Hubballi. Sir has discharged responsibility as a Dean, member of Syndicate, Academic Council of KSLU, and Director of KSLU's Law School for 7 years. Sir has written 1 book, edited 4 books, and more than 85 articles are published in leading law journals. He is one of the experts to submit a research paper to the Committee on Reforms of Criminal Justice, of which Honorable Dr. Justice V.S. Mallimath was the chairman. He has drafted many legislation for the government of Karnataka, including the Karnataka State Human Rights Codes Rules 2006. He has received a commendation for his work in the field of human rights in 2010 and Sir was a member of expert committee for the establishment of Karnataka Rural Development and Panchayat Raj University. Sir evinces a lot of interest in curricular, co-curricular and extracurricular activities and actively involved in legal aid and legal literacy activities for more than 25 years. Sir, on behalf of Christ University School of Law, I welcome you to this national conference. On behalf of Christ University School of Law, I welcome Dr. Revaya Orea, Research Head, Parliamentary, Karnataka Institute of Law and Parliamentary Reform, sir. I welcome our Dean, Dr. Jaydev Nair, sir, and Associate Dean, Dr. Sabna, School of Law, Christ University. I welcome all the resource persons for the today's national conference. Professor Dr. Indrani K.S., Principal of Bishop Cotton, Women's Christian Law College, Bangalore. Advocate Girish Kumar R, High Court of Karnataka. Dr. Anuja S, Associate Professor, Manipal Law School, Bangalore. Dr. Gayatri Y S, Assistant Professor, BMS Law College, Bangalore. Dr. Deepthi Susan Thomas, Assistant Professor, Christ Academy Institute of Law, Bangalore. I welcome all the student paper presenters and participants. I once again welcome one and all for this national conference. Thank you.
Thank you, ma'am. I would now like to invite our chief guest, Honorable Mr. Justice Ashok B. Hinchigeri, Chairman, Karnataka Law Commission, Bangalore, to give the inaugural address.
My good friend, Professor C.S. Patil, Director of KILPA, who is presiding over this function. Respected Professor S.V. Gogara, Founder, Legal Excel Attorneys, Dr. Vadiraj, Director, ESIS Medical Services, research and academic luminaries, Dr. Rivaya Vadiyar, Valmarti, Madam Chaitra, Madam Sapna, all other teachers, and my dear students. Reproductive autonomy is a fundamental right. Article 21 to the Constitution of India includes the reproductive rights of the mother, whether to bear a child or to abort the pregnancy is a crucial aspect of her personhood. Therefore, it has to be left to the self-determination of the pregnant individual. Woman is to be given the right to exercise intimate personal choices. It is because she is the owner of her body. She alone is entitled to exercise control over her body. She alone has to be the choice maker. The pioneering legislation in that field is Medical Termination of Pregnancy Act 1971, which is seemingly, I use the word consciously, seemingly, a progressive legislation. But then, subjecting the pregnant woman to too many opinions and approvals gives an unmistakable impression that she is not seen or treated as a rights holder. Friends, in South Africa, abortion is available on request up to 12 weeks. She is not required to give any reason as to why she wants to have a pregnancy terminated. And after 12 years, that is from 13th week to 20th week, there had to be enumerated socio-economic or medical grounds. And thereafter, even after the expiry of 20th week of pregnancy, if it is viewed that you see it's not safe for her to deliver or to retain the fetus in the womb for a long time, it may be aborted. I have a feeling it's because the people of South Africa, they learned from their experience in their fight against racial discrimination. Resultantly, terminating the pregnancy is also considered as a human right. The situation varies from state to state in USA. In states like Texas, Alabama, Missouri, there is near total ban on abortions, even without exception for rape and incest. In other states like California, New York, and Oregon, the abortion is treated as a matter of personal liberty. In a Latin American country, Mexico, its Supreme Court has declared criminal penalties for abortion as unconstitutional. Personally, I am of the view that a pregnant woman should not be subjected to too many bureaucratic approvals and medical opinions also. What is the role of the doctor in deciding or enabling the woman to go in for a termination? Doctor's role is two-folded according to me. One is, doctor has to confirm that there is pregnancy. One. Two, it is viable, medically viable to perform the termination. Other than these two, nothing more, nothing more, nothing beyond. Other or extraneous reasons, an unwilling, pregnant woman cannot be compelled to retain the fetus and deliver. It is an intimate choice. You need to recognize. And the only one exception is, of course that's again a debatable issue, only one exception is, what if the pregnant woman has completed 24 weeks of pregnancy? It is said, once the fetus is 24 weeks old in the mother's womb, it starts breathing. Once it starts breathing, then the rights of the woman are to be reconciled with the rights of the child, the unborn child, the unborn. Because it's possible to argue whether the right to life includes the right of the unborn child also. It's a debatable issue. But I personally feel and believe not only in humanism but also in lifeism. Every living creature is entitled to live, whether it is in the mother's womb or out of the mother's womb. From the stage of conception, say up to 20, 21, 22, 23, 24 weeks, baby it has not yet started breathing, and mother should be given the absolute right whether to go on with that or to terminate it. But once the child starts breathing, virtually the fetus assumes the life form. Even the mother, in my humble considered view, is not entitled to terminate the pregnancy. If the child, if the fetus on getting the full life form is prematurely taken out of the womb, I read it survives for a day, sometimes for weeks, till it dies. And this should be avoided, even assuming that the fetus has some defects, some deformities, some infirmities. Otherwise, it shows a situation where the child is born with physical handicaps or mental handicaps. Are we going to kill that child because it is born, like this? We are not going to do that. There can't be anything more uncivilized, more unethical than that. Similarly, a fetus which has started breathing has some rights, inherent rights, vis-a-vis even the mother. Even the mother cannot take away the life of a fetus which has started breathing. As I said, I believe in lifeism, that every living creature is entitled to live. Now you may ask, what is the state's interest? What is the government's interest on the issue of the rights of the mother and of the children yet to be born? In my view, the state's enduring interest would be in protecting the prospective children. And in the process of protecting the prospective children, government may impose certain restrictions on the pregnant woman. That's only with a view to ensure that the prospective child is given every care, every attention, every support. State has no role further whether a woman should be allowed to terminate the pregnancy. In my opinion, it can't be at the intervention of the society or the government or the state, or we have been adopting some kind of paternal approach. Following the decision of the Supreme Court of USA in Roe versus Wade, Indian Supreme Court, in the case of Suchita Srivastava, has held that the state has a compelling interest in protecting the life of the prospective child, placing reasonable restrictions on the rights of everyone. Friends, one of the topics in the plenary session is reproductive health and workplace rights. What are the workplace rights? I would certainly like to ask you and ask myself, what are the workplace rights? I will give you one simple situational example. Majority of us are in no position to go to private doctors. People in the upper class, upper middle class, they go to the private doctors, private OBG specialists, obstetrics and gynecology specialists, with a prior appointment, it's at 10:30 or 12:30 or 4:30, 7:30, whatever. But what about the people in the lower class and lower middle class? How many people, how many women, pregnant women, are in a position to avail of the services of government doctors? And of the private doctors. And it is inevitable that she has to go to the government hospitals. In the government hospitals, there is no practice of giving appointments because there is acute shortage of medical manpower and overcrowding of the patients. For any government hospital, you find a long queue. If there is one gynecologist, doctor, in a taluka place, there will be at least 50, 60 women waiting to meet her and get treated by the doctor. Imagine a queue, attender, a clerk in government service, or women in the garment sector or construction sector. If she has to go to the hospital in connection with pregnancy related routine checkups, she has to wait for hours and hours, for 3 hours, 5 hours, 7 hours, 8 hours. She doesn't know when her turn would come. She goes there at 10:30, then wait till her turn comes. It could be 5:30, 6 o'clock in the evening. In the private sector, you can be very sure the employer will not give her the leave. And if she is absent in the government sector, if she doesn't have the leave to her credit, it would be considered as unauthorized leave or leave without receipt pay. See what kind of situation we have created. And many women, because of extreme penury, poverty, she avoids going to the doctor. Okay, what happens? It's all left to doctor. They are reconciled to certain things, and she may say, all right, it's for the God to take care. I need not go to any doctor. For 8-9 months till she delivers, she will not go to the hospital. How do you expect that child and that mother to be healthy? Are we so helpless? Cannot we suggest something? To my mind, Maternity Leave Act has to be amended, or a new Pregnancy Leave Act has to be brought in, has to be put in place. That every pregnant woman is to be entitled to 1 day of pregnancy leave in a month. So that every month she can go to the hospital, have to see herself and see the fetus checked. So you may further debate on that. See, I think it's in the fourth plenary session also. You may further debate on that. And I take this opportunity to make a fervent appeal to you, all the participants, that at the end of the deliberations, on the completion of the presentation of the papers, you pass the resolutions based on consensus and send your copies to me and my friend Patil. Your resolutions would go a long way in guiding us to come out with appropriate legal, right-based legal receipts. We may propose to the government. So I would certainly welcome light from all quarters. From wherever it comes, we would welcome the light. I take this opportunity to thank the organizers of this function for inviting me and for giving me an opportunity to share some of my random thoughts with you. Thank you very much.
Thank you, sir, for your insightful words. I would now like to invite our guest of honor, Professor S.V. Jogarao, founder, Legal Excel Attorneys, Bangalore, to address the gathering.
Honorable Justice Ashok Kinjige, Dr. Jaidevan Nair, Chandrasekhar Patil, Chidanand Reddy Patil, and Principal Madam, and all others. Thank you so much. Considering the paucity of time, I propose to confine to certain aspects focusing on reproductive autonomy, rights and justice. To begin with, I think we need to remind ourselves about what Honorable Supreme Court has unequivocally reiterated in the year 2017 in Justice Pottaswamy's case. The excerpt which clarifies and reiterates about, it reads as follows. The privacy includes the preservation of personal intimacies, the sanctity of family life, marriage, procreation, the home, and sexual orientation. It emphasizes that privacy rights encompass the ability to make choices without interference from the state regarding one's bodily integrity and reproductive choices. For me, this kind of reiteration is very, very significant for all of us. The context of reproductive rights, the National Conference theme, if we take note, I propose to focus on the two recent legislations which had a very checkered history in this country. Almost 2 decades of bill formulation, but ultimately resulted in enactments in the year 2021. I am referring to ART Regulation Act and Surrogacy Regulation Act 2021. Friends, every one of us, we know what these two legislations have done. I am going to raise 5 concerns which I personally very, very much concerned about. Number 1, the most important, the objective in terms of ART is something very well appreciated. Registration of clinics, banks to offer safe and ethical services to restricted people, namely infertile. When it comes to surrogacy regulation, prohibits commercial surrogacy and enables and facilitates a process which is in a sense altruistic in nature. At the same time, there are various offences and penalties for certain types of conduct. If we read in conjunction both the legislations, I think there are 2 approaches which the government of India has followed. One is purely paternalistic, and second, interventionist, thereby resulting in constitutional challenges. In fact, I am sure every one of you are aware, just 2 to 3 years post enactment and enforcement of these 2 laws, you know how many petitions have been filed before high courts across pan-India and Honorable Supreme Court? The number today is continuing and counting, 33 in number, in a matter of 2.5 years. That shows how the framework has resulted in the kind of issues. According to me, both the legislations put together, because of the provisions which dealt according under the respective legislation. First one is choice versus medical necessity. According to me, what exactly is the issue? If I as a person would want to undergo ART, the law says no, it's not a matter of choice. It must be a matter of medical necessity. I think this requires to be taken note. Just now, Honorable Justice made a mention about the rights-based approach. I think this is one red flag which needs to be taken. Second, single woman versus widow or divorcee. ART or surrogacy, please remember, ART, the person, the couple will not only be medically, infertile, that is medical necessity, must also, please remember, the person whom the kind of service, there are some restrictions. A single woman cannot avail ART. Surrogacy also, a single woman cannot. But a divorcee or a widow entitled to have service. How this particular classification stands the scrutiny of Article 14 of the Constitution of India, I think is quite a debate. And already the petition is pending before Honorable Supreme Court. Then comes both surrogacy regulation and ART, they prescribe age. If it is intending couple, what is the age for women and what is the age for man, which means wife and husband. And the person who is, then who is that, what is the age and how many times? How many times the person can donate eggs? If so, how many times in lifetime? Only once. These prescriptions, I always felt that supported by medical justification. I think that's where Article 14 interpretation of Honorable Supreme Court, the rationalization that matters. It is not what the draftsman thinks. No, it must be supported by medical justification. Already Honorable Karnataka High Court in 6 cases, they have not struck down the provision, but they gave relief to the people who say this is particularly arbitrary and doesn't have any medical justification. This is the third one. Fourth one is inexplicable exclusions and inclusions. I think this is where, to what extent the state can really mandate and prohibit is something requires to be examined from a constitutional standpoint. For instance, a single man is not allowed to have service. That is the reason why before the act has come into being, so many of our Bollywood friends, they went on and completed. But this requires to be challenged. In several seminars, etc., discussions, the question that was posed against me when I say why a single man is not allowed. No, single man doesn't constitute family. Of course it doesn't constitute. But what is the problem for a child? No, a man cannot. But there is a divorcee or a widow can. In what way? They say single man may not have any kind of family relationship. But whereas a divorcee or a widow must have been married, please remember, and must have been exposed to the relationship, I think that is where the woman being requested to be treated separate. I think that's where my fundamental question is, to what extent the state can prescribe what is the ideal family and whose interest in what way. I think that's a very interesting question. One more thing, there are so many exclusions, not only single man, single woman. For instance, live-in relationship. Live-in relationship, when it comes to the protection of men or women, Honorable Supreme Court did say this is what requires to be done, etc., etc. But when it comes to LGBTQ, completely the door is closed. We need to really look into it. 377 erstwhile IPC struck down, that is acquired. We have not reached the stage of same-sex marriage, we have no idea. And Supreme Court, you know, the stand is very clear. Therefore, we need to look into, when it comes to reproductive justice, autonomy and rights, to what extent the current framework will stand scrutiny. Finally, select altruism and altruism beyond relationship. I am sure you are aware, altruism is not a new concept insofar as surrogacy is concerned. Altruism we follow in Transplantation of Human Organs Act 1994 as amended 2011. Please understand, a stranger can give an organ to anybody. The law does not prohibit, but the law only says, make out a clear case, why did he or she donates that organ? As a result, the kind of regimen we follow, I don't think even 1% we have approvals for altruistic donation in this country. Because altruistic donation will start with an assumption that there may be a possibility of functionality. But if it is a near relative, the assumption is opposite. That scope for commercial relation is minimal or nothing. I think this is something, in my opinion, is not the kind of approach we need to go for it. If we are not able to really identify whether there is commercial dealing or not, that does not mean the voluntary donation itself must be avoided. In fact, we are proposing to enact the law, amend the law, transplantation, to facilitate any voluntary donor who comes, he or she must be facilitated. You possibly you go for police things. If possible, you conduct any inquiry. But don't say, no, we could not make out why the person is. I think this is something. My own experience when it comes to surrogacy, no doubt this altruism in a limited sense, there is no doubt. But there is no academic article where many people say near relatives only creates web of marketplace. That's what people want. I am a member of competent authority for the last 20 years. Every case is a matter of suspicion because nothing can be ruled out. If that is the case, we need to enact a law where provide the process clearly and encourage volunteering. I think in surrogacy also that applies. Final thought, my dear friends, this is something I feel personally about it. What is the way forward? To reorient both the frameworks with explicit rights-based approach, which is non-negotiable. Thank you so much.
Thank you, sir, for sharing your invaluable knowledge with us. I would now like to invite Dr. C.S. Patil, Chairman, Karnataka Institute of Law and Parliamentary Reforms, Kilpar, Bangalore, to provide the presidential address.
Good morning to all of you. Good morning to the dignitaries and all the speakers who have come here today. I'll be taking up this slot. The reason is because after the president, nobody speaks. So that is why it's called as a presidential address. This is a small bit of thing from my side, which gives us very alarming statistics. And like they say, the numbers speaks for itself. According to the UNICEF and the World Bank, India has the highest number of maternal deaths, which almost goes up to 45,000. And one of the reasons for these maternal deaths are unsafe abortions. The United Nations human rights experts and bodies, they had raised concerns to the Indian government and the human rights violations. And when they spoke about the violations, there are a lot of violations that they have specifically put a red flag to. For example, which includes maternal mortality and morbidity, unsafe abortion, and poor quality of post-abortion care, lack of access to full range of contraceptive methods, and reliance on coercive and substandard female sterilization, child marriage, and lack of information and education on reproductive and sexual health. Now, these are the things which has been specifically flagged. Now, one point that I want to bring to this session is to specifically speaks about in India, if a woman becomes pregnant as a result of non-consensual sex within marriage, because marital rape is not recognized and it is not criminalized in India. Now, what is the legal situation relating to this? Now, under the current MTP Act, as it is amended in 2021, the law does not specifically address pregnancies that result out of marital rape. Of course, there is a judicial recognition to that, which says that rape now will have to include marital rape also, but then I think it requires legislative clarity. Now, this is how the significant gap arises. The first thing is that marital rape is not criminalized in India, and which explicitly states that any of that act by a man with his wife, it does not constitute rape, specifically if she is above 15 years of age. Now, for terminating this kind of pregnancy, the MTP Act allows abortion up to 20 weeks for various reasons. The first reason is risk to the woman's life. The second reason being risk of grave injury or physical or mental health. The next one is substantial risk of serious physical or mental abnormalities in the fetus. The next one is pregnancy resulting from rape, but this typically covers or it refers to non-marital rape, because like I was just telling you, it is not included here, and contraceptive failures. Now, contraceptive failures again has the assumption that it will be for married women and it is not for women who are not married. So in practice, what should it mean? It means that a woman who becomes pregnant due to forced sex within marriage could potentially seek abortion only under, I quote, the mental health provision that is given in the MTP Act, arguing that continuing pregnancy would cause her mental distress. But then how do you prove that? So how does a woman prove that? Now, however, if this requires, then she will have to find a doctor who's willing to interpret the law this way that there is no explicit provision for termination of pregnancy resulting from non-consensual marital sex. Now, beyond 20 weeks and up to 24 weeks, special categories are put here. Now, one of that include rape victims. Again, mind you, it does not include a victim of marital rape because the law does not say that. it does not criminalize marital rape in India, can seek termination with approval from a medical board. But again, we were saying, this does not include a victim of marital rape. Now it says it has to be a medical board. Now what is the legislative framework relating to the medical board? Now it says it will have to be doctors who will be a part of it, and they will have to decide whether there is any kind of danger to the woman's life, or there is some kind of cognitive diseases which the child from birth, because of which it will have to be terminated. Now, to me, this is the non-recognition of marital rape, which directly impacts the reproductive autonomy. So, to me, the suggestion is that when we have the board, just like the way we take the corollary to the POSH Act, which speaks about a board which includes a woman who has experience in the gender issues or who is an NGO to be a part of the board. Is it not possible that we look into, under section 2D, whether the board can have an NGO representative or somebody who is apart from the medical field to be a part of this board? Now, for the reason that when we are speaking about what is the mental trauma that the woman goes through, or what is the mental health that the woman goes through, this is a mental health that goes much beyond the medical health. So this is not just for the doctors to decide. Probably this should have a wider definition coming specifically from the victim of marital rape. So this is one suggestion that I wanted to make, and thank you.
Thank you, ma'am. Dr. Sapna S., Associate Dean and Head of Department, School of Law, Christ Dean to be University, Bangalore, for this wonderful organizational address. Now, I would like to invite Dr. C.S. Patil, Chairman, Karnataka Institute of Law and Parliamentary Reforms, Kilpur, Bangalore, to provide the presidential address. Thank you.
Good morning, everyone. Honorable Justice Sri Ashok B. Ichigeri sir, an altruistic person in himself. Always he loves to be with the youngsters. For that reason, whenever there is an invitation to address a gathering consisting of students, he will not say no. Sometimes it will not be out of context to reveal certain of the information. When he was a sitting judge in the High Court, one day he called me and said, "Professor, what are all the compelling and pending cases against the government, especially of ex-servicemen, those people who lay down their lives on the borders, whether they get their entitlement or not, check and file a public interest litigation, I will pass on this." That is the type of concern Honorable Justice has for the well-being of the common people in the society. When he was requested by the government of Karnataka to take over as the chairman of Karnataka State Law Commission, he was very, very busy in arbitration matters. That was a lot of responsibility, and I should not speak anything about an economic dimension of that. But he said, I will go with the government because it will be an excellent opportunity to serve the society. When he took charge, an odd question was asked, "Sir, how many days you will come to office in a week?" He said, "I will come every day." He is a person who takes no rest. And after assuming office, he has set himself to break all the records. Periodically, he is submitting reports to the government. And he being a sister concern in Kilpa, we find it difficult to race with him and match the progress. And you are witness to the concerns which Honorable Justice has expressed. a right-based model. So that should not be, a law should not be like a recommendation letter. Law should confer an enforceable right. And if it is a right-based model, when Honorable Judge spoke about rights-based model, Professor Jogarao started clapping. That's what I was telling the Honorable Justice. So there is intersection between the thinking of a judge and thinking of a former academician and a practitioner in the field of medicine. Sir, we are really benefited by your address to us, tracing the development from the African law, American law, touching upon Roe versus Wade, and how our own Supreme Court has taken a leaf from that and has tried to put a framework in place. As students of law, we should understand what is the interest of state. Professor Jogarao brought out in an excellent manner the antinomies. I made a list of all of them. To what extent state can interfere, beyond which it should not interfere. Peculiarly, in 1991, I have published an article in Cochin University Law Review. The title is those. I was fresh in the profession of teaching, and I was not knowing that there should not be question marks in the titles. The title of that paper is, "Does abortion law need a second look?" Question mark. Then some elderly professor said, "Look, in ethics there cannot be questions." You have to learn. So I learned it. Started working that day. Because at that time, after Roe versus Wade, there is another judgment. Webster versus Reproductive Health Service. Yet that judgment had come, that's what that made me to think about that. And sir, I have written a 2-page article in derogation of her person, or in inverted commas. Therein I have tried to prove that your woman is not the owner of her body. She is not the master of her body. And I felt so happy when you asserted that it is her body and she is the owner of it. And she should have the right to decide how the body is to be used. And as youngsters, we should be thinking in a very vibrant manner, taking this cue from the address of Honorable Justice to pass a very strong resolution and fight for keeping a legal system in place wherein at the end of 75 years of independence, I should have right on my body, at least. That is one area which Honorable Judge referred to, which requires a very, very serious consideration. We are really benefited by the address of Professor Jogarao. The exercise continues and he has embarked upon a very serious research in this field, and I am looking forward that very constructive things will come out of Dean sir, Dr. Jayadevan Nair. I like him for his cultured ways of behavior and gracious presence, and such a amiable person. Thank you very much for being with us, sir, in the inaugural function. As always, Dr. Sapna, Madam Valarmati and Madam Chaitra, they have taken all the trouble in putting all these things together. Compliments to you and Professor Indra Madam, Professor Anuja from other institutions, they have raised the occasion, and names I cannot take because one of the rules of civic etiquette is that you should not take wrong names. So, thank you very much for the opportunity. Look forward to be benefited by the discourse that you mentioned. Thank you very much.
I would now like to invite Dr. Jaidevan S. Nair, Dean, School of Law, Christ Deemed to be University, Bangalore, to felicitate our guest of honor, Mr. Justice Ashok B. Hechingiri. Further, I would like to invite Dr. Jaidevan S. Nair, Dean School of Law, Christ Deemed to be University, Bangalore, to felicitate Dr. C.S. Patil. Dr. C.S. Finally, to felicitate Professor S.V. Jogala.
Have you taken photos?
I would like to invite Dr. Valarmati to felicitate Rivaya Orier, sir. As well as Sapna S., Assistant Dean and Head of Department, School of Law, Christ Deemed to be University.
Sir, I will escort you.
Finally, I would like to invite Dr. Chaitra R.V., Assistant Professor, School of Law, Christ Deemed to be University, Bangalore, to deliver the vote of thanks.
Good afternoon, everyone. It's my honor and privilege to deliver the vote of thanks on behalf of the organizing committee for this prestigious national conference on reproductive rights and policy transformation. First and foremost, I extend my deepest gratitude to our chief guest, Honorable Mr. Justice Ashok Hechingiri, Chairman, Karnataka State Law Commission, for taking time out of his busy schedule to grace this occasion. Sir, your enlightening address has set the tone for meaningful deliberations today. A special thanks to our guests of honor, Professor S.V. Jogara, Founder Legal Excel Attorneys, Bangalore, for your valuable insights and unwavering commitment to gender equity and transformative policy. Your words have truly inspired us, sir. We express our profound gratitude to Dr. C.S. Patil, Director KILPAR, and Dr. Revaya Warrior, the Research Head of KILPAR, for their generous support and funding of this national conference. Their commitment to fostering academic disclosure and progressive legal reform has made this event possible. This collaboration with KILPAR not only adds credibility and strength to our efforts, but also reinforces our shared vision of building a more informed, equitable, and right-based legal framework in our country. We are sincerely thankful for this partnership and look forward to many more such collaborative engagements in the future. I would also like to acknowledge the presence of our Dean, Dr. Jaydevan S. Nair, and Associate Dean, Dr. Sapna S., whose constant support and encouragement have been instrumental in making this conference a reality. Your leadership continues to guide and motivate us. To our distinguished speakers, panelists, and participants joining us from across the country, thank you for your participation. Last but not the least, I would like to sincerely thank the organizing committee, volunteers, technical support team, and administrative staff for their tireless effort, attention to detail, and seamless coordination. Once again, thank you all for being part of this important journey. Thank you.
Please note that we now have a 10-minute tea break, after which we shall reconvene in the same room for the plenary session, where dignified academic scholars will be posing their views on certain topics related to the theme of the conference. Thank you. Greetings. I would firstly, before we begin, like to extend our warm invite to Dr. Sapna S., Associate Dean and Head of Department, School of Law, Christ Deemed to be University, Dr. C.S. Patil, Chairman, Karnataka Institute of Law and Parliamentary Reforms, and Dr. D. Varadaraj, ESIS Medical Services on the dais. A very good morning to everyone present here. I, Sanjana Rao, on behalf of the Gender Studies Committee, warmly welcome today's dignitaries, speakers, participants, and all those present here for the plenary session. Our speakers for this session will broadly dissect almost all of our thematic tracks for the conference and provide thought-provoking insights. I would now like to call Dr. Vallarmati R. Professor, School of Law, Christ Deemed to be University, to extend a warm welcome to Dr. D. Varadaraj.
I welcome another guest of honor, Dr. Varadaraj, Director, ESIS, Medical Services, Karnataka. Sir has completed his MBBS and MS from KMCRI, Hubballi, joined ESIS Medical Services in 1995, and Sir worked as a general surgery HOD for 26 years at ESI Hospital, Mysore, and Sir was Medical Superintendent ESIS Mysore for 3 years. Sir, on behalf of Kilpa Christ University School of Law, I welcome you to this national conference, and I request you to address the topic.
Good morning, everyone. At the outset, I want to thank Christ University for involved in getting me for this program. I'm sorry I was unable to come on time due to some other issues. Coming to the point, to talk about medical termination of pregnancy, there are two things to be considered. One is what time is safe to get a pregnancy terminated. Another is what are the problems you can expect during the termination of pregnancy. And third thing is the legal issues involved in the termination of pregnancy. Legal issues, there are the more qualified people that need to talk about that. I will be telling you about the termination of pregnancy and the safety aspect. So for a pregnancy to be confirmed, you need 6 weeks after the last missed period. Why 6 weeks? By the end of 6 weeks, you get heart sounds, fetal heart sounds, FHS we call it as, which can be identified by ultrasound. So only when you can identify fetal heart sounds, then we consider that pregnancy as a viable pregnancy. So before that, pregnancy test may be positive and the fetal ultrasound should not have appeared. So, after confirming the viability of the pregnancy, you think about the other services to be given to the mother as well as to the counseling to be done for the parents. So, coming to the termination of pregnancy, when is the ideal time to terminate the pregnancy? Ideally, it is 49 days is the safest period. 49 days means 7 weeks. There are 3 methods of termination. One is by taking pills, medical termination with pills. Other is surgical termination. Surgically, there are 2 methods. One is DNC, dilatation and curettage. Other is suction evacuation. These are the things we use to do termination of pregnancy. After 49 days, which is the next most safer period? That is around 11 weeks. So up to 11 weeks, you can terminate the pregnancy medically, but it is advisable to go for the surgical part for the pregnancy which has exceeded 7 weeks and which falls between 7 to 11 weeks, because there are 2 chances with termination of pregnancy using a pill. While giving the tablets, we give mifepristone and misoprostol. How do they act? Mifepristone separates the fetal parts from the maternal womb. So that is the part. Once the fetal part is separated, it stops getting the nutrition from the mother and the baby dies. The misoprostol, how it acts is, it causes uterine contractions and tries to expel the baby which is already not alive. So these two act in together. So initially we give mifepristone, which separates the baby from the mother's womb, and after 48 hours, once we give the misoprostol tablet, that tablet tries to expel the baby which has already been separated from the mother. So this is the method using the pill. Next comes to the dilatation and curettage. So for dilatation and curettage, we need to counsel the patients about the anesthesia. Anesthesia may be given in the form of local anesthesia, where we give the block around the uterus. The patient will be conscious, but they will be aware about what is happening. So this is one of the things that is called as a paracervical block. That block will be given using the xylocaine, which causes about 30 to 45 minutes of sensory neural block in that area, and the patient will not be aware of the pain during that period. So dilatation means the opening of the uterus, which we call it as the cervix, that will be enlarged using some instruments, so that whatever is there inside, then it will be curated and it will be evacuated. So there is the dilatation and curettage, or commonly called as DNC. So this is one procedure. Up to 9 weeks, this can be done very safely with paracervical block, or after 9 weeks, up to 11 weeks, it can be done under general anesthesia, where the patient will be more comfortable and the doctor will also be more comfortable. So if the counseling is the most important thing for pregnancy. You take the pregnant woman along with the parents or the husband and do the counseling. During the counseling, initially we try to explain to them to continue the pregnancy if it is feasible and possible. How? Because any interference with pregnancy, you are going to deal with a new life. So initially we give the option up to the patient to continue the pregnancy as far as possible. Due to various reasons, if the parents are not willing to continue the pregnancy, then they will be explained of the risks involved of the termination procedure. If it is to be done through a pill, then we tell about the course, how to take the medicines, when the bleeding will start, what to expect after the pill, all those things. Once the pill is given, usually the bleeding starts after 48 hours, after the misoprostol, 6 to 8 hours after the misoprostol tablet is given. Initially, first 2 days bleeding will be normal. Second to fourth day, the bleeding will be heavy, and by 7th day it should come down. But some people will go on having trickles of blood up to 14 days. How do you confirm that whether the pregnancy is terminated? Do your ultrasound after the 7 to 10 days. If the bleeding is persisting or if the bleeding is heavy, that may indicate that it is not completely evacuated. If the bleeding has stopped, then probably you can give the choice to the patient to go for the ultrasound, or you can wait and watch. So what do you confirm in the second ultrasound? You see further whether there are any fetal parts are remaining or whether all the parts are evacuated, that you see in the confirmatory ultrasound. So this is about the pill. Once you come to the DNC, that itself is since it is a surgical procedure, that depends on the skill of the doctor, and most often it is done, if it is done within the 7 weeks, it will not cause any other problem other than, and the bleeding will also be less. So after 9 weeks up to 11 weeks, this period, after 7 weeks up to 11 weeks, this period the baby will be little bit more developed. So the bleeding will be more if you give the pill during that period, and the chances of incomplete evacuation of pregnancy will be more. So while counseling, if the pregnancy is more than 7 weeks, we usually ask them to go for the DNC option or the suction and evacuation option preferably. If the patients insist, then we give the tablets with the option that there will be heavy bleeding and they need a check curettage to complete the termination process. All these things will be confirmed after the termination part is over by doing a check ultrasound, repeat ultrasound, where you will confirm whether there are any products are remaining or whether any evacuation has been completed. So after 11 weeks, then the question of safety of the mother as well as the incomplete evacuation part comes. So 11 weeks to 20 weeks, you require 2 doctors for the confirmation and proceeding with the termination of pregnancy. During this time, we use both the medical option as well as the surgical option. Medical option, we do give some tablets. By placing the tablets, instead of giving orally, we give the tablets and ask them to, it will be kept in the cervical opening region so that it will cause slow dilatation of the cervix. Afterwards, it will be easier to evacuate the pregnancy by doing the surgical procedure. So the question of legality comes after this 20 weeks. 20 to 24 weeks, the pregnancy can be terminated, but with the proper explanation to the parents about all the complications to the mother as well as the baby, because the baby will be completely developed by the end of 20 weeks. We call organogenesis. Most of the organs will be already generated and they will be visualized on the scan. We do a scan around 20 weeks to know about the organogenesis and any anomaly. If there is any anomaly, then also the question of going ahead with the pregnancy comes. So after 20 weeks to 24 weeks, why should you terminate the pregnancy? If the pregnancy is causing harm to the mother, then the question of termination of pregnancy comes. If the pregnancy is more than 20 weeks. And if the pregnancy has happened due to unnatural things like rape, or if the patient is mentally unsound and has not noticed pregnancy for a quite late part, then also the question of pregnancy termination comes with the legalism as well as the double medical opinion. Considering all these things, we take the opinion of the Honorable Judiciary as well as the doctors, two doctors opine, and with the permission, due permissions legally, then termination of pregnancy will be proceeded according to the case-based scenario. So this is about the termination of pregnancy. Thank you very much. Any questions, please? Yes.
But in the advanced stage, the two medically qualified doctors say that it is not abortion, whether woman has the right to save abortion.
Woman, if it is
Beyond 20 weeks,
beyond 20 weeks, no.
woman has no right.
I don't know, but please apply to me.
It is in the name of the women. In my body, I am pregnant. I should decide whether I want it or not. What these two doctors come in the future and decide whether woman should have abortion or not. The rules, medically qualified.
Two qualified doctors. No, safety, because the baby will be viable. The very organ will be developed. It will be a human which is in a smaller form. So the question of ethical issues, all those things will come.
Yes.
We need two doctors' opinion. Could you please once? We need two doctors' opinion to confirm whether the pregnancy should be continued or not. So who will appoint?
Not confirm. To decide whether the pregnancy should be terminated.
Should be terminated or not. So who will appoint those two doctors? If it is the patient
Those
side.
who are with postgraduate qualification in obstetrics and gynecology, any two doctors who have a good standing in the public, they can be judges.
Our question is who selects them?
That is the patient's choice. And afterwards it should be legally, or what you can tell, verified.
If it is, I'm a patient, I'm the mother, I can select two doctors and I can get the opinion from them. I know them personally, so I'm saying that I'm persuading them that I can't continue. So will it be legally valid or how?
You are
No.
asking the wrong question to a medical doctor. Legally valid is you doctor answer or CL
Legal part, see, even if the medical personnel decide, they will take the legal justification to continue or avoid with the, so if two doctors opine, then even with the, unless there is a judicial opinion to go for the termination, it is not advisable.
Thank you.
Yes, please.
Good afternoon, sir. I wanted to know the medical consequences in case there is a minor girl, let's say of about 11 or 12 years old. Good afternoon, sir. I wanted to know the medical consequences regarding, let's say there's a minor of 11 or 12 years old and she is in an advanced stage, gestational age of her pregnancy, let's say around her 28th or 30th week. And now when she comes to the court seeking for an abortion, and the court would most likely deny it on the grounds that this would cause harm to her life and based on the fetal viability. Now my question is whether the effect of the abortion procedure on that girl or the pregnancy itself, the delivery itself on that girl, which would be more detrimental to her health?
Abortion usually will be more detrimental. The continuation of pregnancy with the medical supervision, it can be done.
So in such cases, the delivery is more preferable
They
than
will
the
be
abortion.
given the medical supervision, constant medical supervision, and it will be seen to it that she will deliver it safely.
So at that stage, is abortion more detrimental to her
Dangerous.
than
It is more
pregnancy?
dangerous.
Because she has to undergo the process of delivery, which will affect her physical, mental, and emotional health. So you're saying that is better than abortion at that stage?
Abortion is more traumatic psychologically.
So what if she's a survivor of rape?
It has to be decided by the courts.
Thank you.
Any more questions? Thank you very much.
Now, I would like to invite Dr. Sapna S., Associate Dean and Head of Department, School of Law, Christ Deemed to be University, to felicitate Dr. B. Varadaraj, Director, ESIS Medical Services. First, we will be covering abortion and reproductive rights and its surrounding spheres under the medical termination of pregnancy (MTP). I would now like to invite our first speaker for the same, Dr. Anuja S., Associate Professor, Manipal Law School, MLS, Bengaluru.
Good afternoon to one and all. Thank you so much for this opportunity and my heartfelt greetings to Professor C.S. Patil, Dr. Varadara, Dr. Sapna, Professor Jayadevan, Dr. Valarmadi, who invited me to be a keynote speaker for this event, and my friends Professor Indrani, Dr. Deepthi and Dr. Chaitra and all who are there. So I was telling that this is a memorable event, always to see your colleagues and always it's good to address the students as well. It's always an amazing opportunity. Thank you so much for this opportunity. Thank you so much to this vibrant team who have organized this specific theme on reproductive rights and policy transformation, School of Law, Christ Deemed to be University, Bengaluru, and the Karnataka Institute for Law and Parliamentary Reforms. This is a very contentious issue, and maybe I would like to start with a personal note of mine. 10 years before, I was sharing the panel with regard to a discussion on termination of pregnancy with Advocate Flavia Agnes, the women's rights activist and lawyer, that too Government Law College Trivandrum at Kerala. So at that point of time, the contentious issue was the 1971 MTP Act and the concerns that were coming up specifically in the context of a need for the greater or increased gestational limits at that point of time, which needs to be coming up as a part of the legislative amendments. So the bill was in the process then. So after 10 years, I'm here, much water has flown. Now we are with the 2021 MTP Act. We have the judicial interpretations coming up. We do have the new medical boards that are constituted specifically under the amended act. So it is in this context, so I always feel that law in text, law in context and law in action is always very important, and it is highly focused, it is to be highly focused when it comes to such kind of contentious issues. As we go back to the human rights standards or the protocols, the international trendsetter in the health field, World Health Organization always says the gestational limits or maintenance of gestational limits is highly discriminatory in nature and it's not evidence-based. So that is one of the specific ideas that comes from World Health Organization. They have figured out certain structural barriers and challenges when it comes to termination of pregnancy. One is that they feel that the criminalization of specifically the pregnancy situations leads to a whole lot of unsafe abortions. So what is the problem with unsafe abortions? It leads to larger maternal mortality and morbidity rates. So there is a larger policy issue surrounding across the globe with regard to providing for legal and safe, accessible ways of termination of pregnancies that too respectful of individual rights. This is what is exactly quoted by World Health Organization. Promotion of legal, safe abortions, accessible to them and respectful of the individual rights. That's where we need to understand the human rights understandings with regard to this contentious issue of termination of pregnancy, the medical issues related, etc. I believe this is not only a medical legal issue or the problem, it is highly human, it is deeply rooted in politics, it is deeply rooted within the socio-cultural norms, and I believe it is highly gendered as well. That's where the gender discrimination comes in. That's where the difficulty, the problems of stigma, the harassment, the ostracization that happens, specifically that revolves around this issue of termination of pregnancies. The concerns of unmarried women comes in, the concerns of married women comes in, the concerns of human rights issues of the rape victims comes in, the survivors of rape comes in, the incest comes in. These are certain eugenic and the humanitarian grounds that has been incorporated into the legislation to understand or to bring in the human rights understandings to this particular aspect. So as we travel around the world, how it looks like when it comes to termination of pregnancy. The so-called countries like UK, US, which we infer that they are the most settled countries wherein feminism has deeply, has got deeply rooted within its domain. Let's see how the law looks like there. In US, with the new Dobbs decision coming up, overturning the Roe versus Wade, the most acclaimed Roe versus Wade decision, now the federal right with regard to termination of pregnancy is totally taken away. It is the prerogative of all the states to come up with their own laws. Obviously, many of the laws are very much related to the conditional restrictions or the conditionalities attached to the rights of women, specifically related to two important reasons. One is the substantive fetal abnormality that is coming up, and the other one is risk to the life of the woman concerned. As we go to UK, we do see a prototype of a legislation that we see in India, the 2021 Act, with a 24 weeks of gestational limit that has been legally prescribed, and accordingly, the abortions that can be legally terminated. As we move to certain countries like Ireland, Sweden, and very many other Christian-dominated, Protestant beliefs-dominated countries, you see the upsurge of the pro-life choice coming up, giving precedence to rights of the child and not the rights of the women. I'm not specifically denying the situations of pro-life choices, but the more precedence when it comes to judicial interpretation and the legislative reflections, they are in favor of pro-life choice. Then as we come down to India, with looking into all these other countries, we do have Islamic countries as well with strict bans on termination of pregnancy. So what is the problem with these kind of different conditions that are brought in when it comes to termination of pregnancy? The problem is the more the confidential it is, the more the stigmatized it is, the more the chances of unsafe abortions comes in. And when it comes to unsafe abortions, World Health Organization statistics shows around 60% of illegal terminations or abortions happen specifically within South Africa, and more in lower income countries, around contributing to 20% or 30% to the Asian region. So again, it becomes an economic policy, a welfare policy, a public policy issue that strictly looks at the maternal mortality and the morbidity rates. That's how the policy issues gets into this particular situation. So as we go down the lane and when we come to India, we do see a transformation, we see change transformation that has happened from the 1971 Act to the 2021 Act. From 9 to 12 weeks, 12 to 20 weeks, in the 1971 Act, the gestation limit has been increased to 20 and then 20 to 24 in the 2021 Amendment Act. So let's understand how this paternalistic, the once so-called paternalistic act, this act first of all came in with the idea that only the doctors, when they get in with regard to certain surgical and medical methods of terminating the pregnancy, it can be a legalized abortion. So we did have the concept of criminalizing the situations of abortion, and we need to bring in decriminalization. That's why we always bring in the idea of provider-centric legislations. When a registered medical practitioner goes in for termination of pregnancy, they will have to follow the procedures and norms prescribed by medical termination of pregnancy. And by termination, it means basically using the surgical and the medical methods which Dr. Varadara was referring to specifically. And as we look into the nature of 1971 Act, it was paternalistic in nature, and more of that, it was a population control measure that was coming up in the form of MPP Act 1971. Now we see the transformation in 2021 as it is being highly applauded as a rights-based legislation. So let's understand how this rights-based understanding over a period of 71 to 21 has occurred. So now there is a new provision specifically. So somebody was asking about what with regard to the situations of rape, etc., when unwanted pregnancy happens. So here what happens is the gestation limits are increased as of now. Up till 20 weeks of gestation weeks, you require only the approval from one registered medical practitioner. As we move to 20 to 24, 2 medical practitioners' approval becomes necessary. And beyond 24 weeks, and that too for substantive fetal abnormalities, you will have to be bound by the decision given by the medical board. I believe the medical board is whole the domain of Advocate Girish Kumar, so I'm not touching upon that because I'm not a real stakeholder when it comes to giving the experiences from the medical board. So, as we see the increased gestational limits over 2021 Act, we also see a new idea of any woman. Earlier the idea was only married woman can go in for termination of pregnancy. Now you see a clause called as any woman or her partner. Say for example, if in case there is a failure of the use of contraceptive method, basically to limit the number of children, and there is a failure with regard to using of that contraceptive device, any woman or her partner, that is a new clause that has been added. So any woman includes unmarried women as well. That's how the judicial interpretation has come up in X versus Principal Secretary, Health and Family Welfare Department, NCT of Delhi and another. So that's a 2022 decision that we see after the 2021 Amendment Act. So it includes unmarried women as well, and also when you have included any partner or her partner, it includes the transgender population, the gender variant population. So those gender variant populations whose sex reassignment surgery has not been done, who still has got functional ovaries and who has the potential of getting into motherhood, and they are into unwanted pregnancies, their case also has been brought in as a result of judicial interpretation of this 2022 decision coming up. And that's how we say unmarried women has also been brought in there through judicial interpretation. Cisgender and gender variant groups are also brought in over there. So specifically in the context of failure of contraceptive measures. Then a specific category of women has been brought in through the rules as well, wherein between 20 to 24 gestational weeks, they can go in for abortion. That too with the approval by 2 registered medical practitioners. Basically, it is on favor or oriented towards the risk to the life of the women or any fetal malformalities. So let us see what are the specified categories of women coming up. Women survivors of rape, sexual incest, minors, then specifically women with mental illness leading to mental retardation, then differently abled women. Then you also see specifically those women whose marital status has undergone a change during ongoing pregnancy, including divorcees and widows. That is how it is said. And at last they have also added a specific category called as any woman wherein they get into an unwanted pregnancy because of any humanitarian emergency disaster setting as proclaimed so, or officially notified by the government. These are the specially classified women who could go in for legal abortions under MTP Act 2021 with the help of approval from 2 medical practitioners. So what happens beyond 24 weeks? It is always within the domain of the judicial permission, again to be decided by the, and again the concerns of viability of the fetus comes. So this is how the idea of specified categories has been brought in. Then a clause has been brought in with regard to strengthening the confidentiality clause. To no one should the information be divulged with regard to any woman who comes in for termination of pregnancy other than to an appropriate officer as per the law in force. That's all. So it need not be divulged to anyone. So again the confidentiality and privacy concerns has been taken into consideration. With all these new rights-based, we always say it's a constitutional right, it's a human right coming under Article 21, Article 14. We quote Justice Puttasswamy's case to say that privacy includes the personal intimacy and also the sexual and the reproductive rights. Right? So with this law, and if we start interpreting from the law, judicial interpretation is the art wherein law speaks to the world, taking into account what is the present and also taking into account the facets of wisdom, compassion and adaptability. So a reflection of this judicial interpretation comes in the form of X versus Principal Secretary, a matter that came up before the Supreme Court of India. An unmarried woman from Manipur, a permanent resident of Delhi, she was into unwanted pregnancy. She got into unwanted pregnancy situation and her partner cheated on her. So she requested the court saying that, see, I don't want to continue this pregnancy to term, and I belong to an agriculturalist family and I have socio-economic reasons behind wherein I should be going in for termination of pregnancy. Plus, cheating by my partner has led to the mental anguish that has come. So mental anguish is also one of the ideas, concepts that has been included under 2021 Amendment Act. Any woman who is a survivor of a rape or any woman wherein the contraceptive failure happens, there is a mental anguish that is likely to happen wherein it can lead to the high risk for that woman, whether it's physical or mental in nature. So mental anguish has been textually interpreted under the law, MTP 2021. So this was a wonderful case that came up before Supreme Court, and the 3-judge bench led by Justice D.Y. Chandrachud came up with a wonderful, amazing rights-based structure on reproductive rights. Any violation of privacy concerns, confidentiality concerns, or any concerns that affects negatively the rights of women is an affront to right to dignity of the woman. That was categorically being stated by the Supreme Court. And this unmarried woman's case was totally discarded by the trial court, but that case was taken up and Supreme Court espoused the cause of including unmarried women within the context of medical termination of pregnancy, because he said, or it was stated in the judgment, that creating a distinction between the married status and unmarried status with regard to seeking in or having accessibility to termination of pregnancy is constitutionally discriminatory in nature. And the court was vociferous that came upon with saying that always the material circumstances of the woman, the social, economic circumstances, the disruption to the work that can happen, the difficulties that she will have to face, the trauma that she will have to face in the society, all needs to be taken into concern. And when you are giving these rights to married women, there is no way the deprival can happen to the unmarried woman. The judgment went in favor of this unmarried person, and that was acclaimed as a wonderful interpretation of MTP 2021 Act as a rights-based legislation. A year after, 2023, another case came up before Supreme Court, a very interesting case, X versus Union of India. So why we are looking into judicial interpretation is how the textual interpretation gets reflected in the form of compassion, respectability and adaptability. That is what we are looking for. So X versus Union of India was a case of a mother who already had 2 children and she wanted to abort the 3rd pregnancy, which she considered as unwanted one. And why she didn't realize it, that was a case, she came to the court somewhere around beyond 22 weeks. So she wanted to terminate the pregnancy and her reason was, see, I am already suffering postpartum psychosis, I have postpartum depression. It was only during the when I took my 2nd child to the doctor because of a medical condition called as lactational amenorrhea. That is how it is understood. The woman will not be menstruating and will be into a breastfeeding situation at that point of time, wherein she couldn't diagnose that she was she was pregnant. So at a later stage, that is why she had to approach the court and to request for the termination of the pregnancy. So the first medical report came saying that, see, there is no problem with regard to the fetus, but as far as this particular situation is concerned, taking into account the postpartum psychosis depression, there is a problem of mental anguish that could be taken up valid as far as a woman is concerned, and the woman can go in for termination of pregnancy. A email came from the doctor saying that, see, when you go in for such kind of procedures, there is a problem with the viable fetus that is there. There is no problem with the fetus as of now, as per the medical board records. So if in case you go in for the procedures, it may kill the baby. So there is a procedure that is required before this to stop the fetal heartbeats. In US, there are certain laws called as heartbeat laws, wherein if the fetus heartbeats is diagnosed, the pro-life choice is taken into consideration. But in India, we don't have such kind of laws. We go by the general conditional restrictions imposed by the MPP Act 2021. So, taking into account that there is a viable fetus as per the medical board case situation coming up, the 2-judge bench consisting of Justice Nagaratna, B.V. Nagaratna and Justice Hima Kohli gave a split verdict. Justice Nagaratna said, there is no separate existence of a fetus. Other than that, without the existence of a mother. It is already intertwined with each other. So we need to go in for the request of, favoring the request of the woman to terminate the pregnancy. Justice Hima Kohli said we need to go in for a pro-life choice. Since there was a problem of this kind coming up, another 3-judge bench came up, led by Justice D.Y. Chandrachud, and the whole idea was looked into, the mental anguish, the report from the medical board, everything was looked into, and the court said, purely going by the textual interpretation, sorry, the case is not fitting into section 3(2)(b) rules of MTP Act, and also there is no problem with that any urgent kind of interference is required or intervention is required with regard to the situation of the woman. There is no risk with regard to the life of the woman. Plus, there is no problem with the viable fetus as well. So, we go by the promotion of the pro-life choice. And even though we had the larger ideas of mental anguish coming up, the idea of mental peace of mind that ought to be taken care of the woman, even though there was the reflections and evidence from the postpartum depression, the court went by the pro-life choice and the lady's request with regard to termination of pregnancy was totally discarded. So 2021 Act exists, 2022 case with a purposive interpretation is there. We have the 2023 case with, again, the case going back to the larger decision making done by the medical board. Very interestingly, one line was included in the judgment which I felt that is highly interesting. The onus of proof falls on the woman to show that she is urgently in need of termination of pregnancy. And we are talking about the rights-based approach. Still, the contentious issue is there. It's the debated topic. We talk about feminist jurisprudence. We talk about right over the body and right over the decisional autonomy, right? World Health Organization says, please don't see reproductive rights as a subset of the right to health. It is actually a pillar of gender justice. So the need of the hour is to understand the law in text, context, and also in action. Where we stand and from where we have traveled and to where we are heading to. That's where I believe we need to have a choice from control to choice and also from silence to agency. Thank you so much.
26 weeks paternity leave. Wipro gives around 8 weeks. and Tata Consultancy gives around 15 days. Now, for a woman to move high in her career without the maternity or the reproduction choices, she cannot go ahead. You find today women are all postponing their reproduction area. Reason being, the moment they know that they are in the path of their reproduction process, then definitely there is a stop by the employer. The employer would start looking out for alternatives and would not allow the woman to climb the ladder, and which is the major setback for every woman. We do not want this to happen to us. If you remember the case of Air India versus Nargis Mirza, the first time, where a 21-year-old was pregnant, but then Air India said, no, you need to terminate your employment itself. Now that is not done. However, Supreme Court went on to say, yes, we should remove that rule from the Air India rules. Then if you see the Municipal Corporation of Delhi versus Female Workers Master Rolls, where the first question was raised in regard to people of manual labor, they are on contract, whether they require it. Just because it is any other employment not under an organized area, Supreme Court went on to say no, they also need to be covered under the Maternity Benefit Act. In the Life Insurance Corporation Meera Mathur case, it was in regard to, there was a form laid down in that, wherein they said that you have to fill in about your menstrual cycle and the pregnancies. Now that is a right which cannot be disclosed or need not be disclosed. Supreme Court said such a law has to be struck down. There was yet another case wherein the central government said, as per the financial rules, that you need to show a gap of 2 years from your first child to second child when you are using your Maternity Benefit Act. Again, Supreme Court says that such a rule is not available under our Maternity Benefit Act, and therefore you need not follow the gap rule. So in this way you find women at every strata of their life being asked to come down. Don't climb the ladder. But if you climb the ladder, you need to follow the rules. Now, paternity loss or paternity benefit is the change that is required today. Men from their patriarchal outlook are becoming more accommodative of the women. They want to share in childcare and also in the area of family, other areas. And therefore, when paternity benefit is also given, definitely we can get a society where both men and women join together and work towards the welfare of the nation, getting an overall improvement of the economy of the country. At the same time, the social strata also will be safeguarded. Now, because of this climbing the ladder, women having late pregnancies are actually affected mentally and physically. Today you have the endometriosis and PCOS, which are the main reasons as to why there is the postponement in your pregnancy. Women do not have time to go to the hospital. As they said, we do not have the best hospitals. If you look into the lower strata of working people, of course, we can go for a private doctor, but they would not be able to go. Like our justice said in the morning, when they are unable to reach to the doctors, they do not know what is actually wrong with them. And that is when other complications come in, depression and other areas, because of which they are unable to concentrate on their employment, which they lose their economic input into their family. Therefore, it is very necessary that the bill that is pending on the paternity benefit be applied so that there will be a better family setup with a better section of children or citizens of India. Thank you.
Thank you, ma'am. Now, I would like to invite Dr. Gayatri Bai S., Assistant Professor, BMS Law College, Bangalore, to share her thoughts on consent and bodily autonomy in reproductive health care.
Very good morning. C.S. Patil sir, as well as Valarmathi ma'am and Sapna ma'am, my other co-presenters and my dear participants. The topic which I have chosen for today's presentation is reproductive rights. We have different aspects of reproductive rights, but the line of research what I have undertaken here it is the impact of reproductive rights on personal laws. When we say reproductive rights, as all of us we know, it is an exclusive right which is available only to women. So my presentation of the research it is reproductive rights which will be exercised by a married woman within the institution of the marriage. So what is its impact on personal laws? My presentation is divided into three parts. The first part is the reproductive rights and the body autonomy within the institution of the marriage. Second, reproductive rights and the conjugal rights of a husband within the institution of marriage. And the third is same, reproductive rights and medical termination of pregnancy by a married woman without the consent of the husband. So these are the three important aspects. So when we say a reproductive rights, thanks to Supreme Court of India, Nargis Mirza case, as ma'am rightly pointed out, expressively in its judgment, it is a part of Article 21. But when it comes to at international level, 1994 UN Conference on Population and the Development expressively brought the idea of the concept of reproductive rights. What is this reproductive rights all about? Bringing to my presentation, I will say reproductive rights is an exclusive right of a woman to say yes or no with respect to sex, with respect to child, with respect to family planning. Because I said personal law in connection with reproductive rights. As all of us we know, when we say a reproductive rights, the first important concept which is related to reproductive right, it is a body autonomy. I think all of us we know right from Nargis Mirza case or a recent case of Joseph Shini versus Union of India 2018 or any other cases. Supreme Court has upheld the body autonomy which is a part of... Okay, thank you. So this is what I've already said. So these are the few cases decided by the Supreme Court where upholding the right to reproductive rights, that is, the reproductive rights are part of Article 21, which includes right to privacy, body autonomy, all those things. So first we'll understand the body autonomy, and that too within the institution of the marriage and with the reproductive rights. As a layman interpretation, the body autonomy is my body, my choice. I can do whatever I want. But please remember, I said reproductive rights of a married woman within the institution of the marriage. When we say marriage, it is not just a relationship between the husband and wife, but where the other family members likes, dislikes will also enter. So when we say a body autonomy, yes, a wife can say no or yes to a sexual relationship with the husband, which is a well accepted theory in India. Yes, you can say yes. You cannot, husband cannot force for a sexual intercourse within the institution of marriage. If you force, right, Article 21 says it is a fundamental right, you have to respect her privacy. But what is a remedy which is available to husband? Right? That too from the perspective of protection of the institution of marriage in a country like India, where we consider marriage maybe a sacrament or maybe a contract. So when you highlight this particular point, a fundamental right body autonomy, a reproductive right, exclusive right which is available to a married woman. So how to protect the interest of a husband? You cannot violate 21. The remedy which is available to husband is just go for a divorce. Because many cases where if a woman says no for a sex, exercising her reproductive rights, you cannot ask her to violate, or you cannot violate her fundamental rights. The ground which is available for husband, yes, file a petition for the family court and ask for a divorce. It becomes a good ground for divorce. Why? Within a marriage, institution of the marriage, after the marriage, immediately without having a valid reason, if a married, that is a wife says no for the sex relationship, sexual or this one, in that circumstances it is treated as a mental cruelty on the part of husband, so husband easily gets a divorce. But my point of argument here is, in order to protect the interest of the institution of the marriage, whether can we give importance to body autonomy, protecting Article 21 of a wife, or should we give importance to desires of a husband? Because as we know, always we give importance to Article 21, nothing else. But this is the area where we need to maintain a balance between the 21 body autonomy of a wife and the second, the rights of a husband from the perspective of protection of the institution of the marriage. So there are so many case laws which clearly says body autonomy should be given more importance. Yes, if she says no, it becomes a mental cruelty. Yes, husband can go for a divorce. But is it easy or is it acceptable in all the cases? Because why I am highlighting this particular point here, it is at present number of divorce cases are increasing in India, especially among young couples. So I'm not just highlighting as a feminist, I'm not just supporting the reproductive rights of women, but we have to think from the other perspective also. So which need to be addressed by the policy makers. So the next it is the point, I think as this I've already said, it becomes a good ground for cruelty, go for us. And the second important here it is your MTP Act. The new amended, all those things. What is important? Because reproductive rights is to bear a child or not to bear a child. It is a reproductive rights choice of a wife. I'm not highlighting on the reproductive rights of a single or a unmarried or a woman. Generally specific with respect to a married woman. So this particular enactment gives preference to a wife, a woman who is a pregnant. And Supreme Court clearly says only with the consent of a mother, that is a wife, the medical termination of pregnancy is permitted. But here what I want to stress here it is, when we say a marriage, it's a rights correlated with a duty, responsibility on both the sides, husband as well as a wife. If husband asks for a child, body autonomy is violated, you cannot force. But on the other side, if a husband says, I want child, by chance a pregnancy takes place, the law supports a woman without the consent of a husband, she can go for a termination of pregnancy. How far it is justified? Because as a husband, even he has a likes, desires and the right to have a child within the institution of the marriage. But when you give more importance to reproductive rights of a woman, body autonomy to a woman, who will take care of or how to manage or how to protect the rights of a husband within the institution of the marriage. Again, here also the law clearly says, without the consent of a husband, if a woman, that is a wife, goes for a termination, again it becomes a ground for divorce. Because without his consent, going for a medical termination of pregnancy by a wife, it is treated as a mental cruelty. Yes, the remedy is go for a divorce, and where dissolution of marriage takes place. Again, it will have its impact on personal laws. It is nothing but where the institution of the marriage is defeated because of these two provisions. And the last here it is the presentation. Yeah, these are the case laws where it is highlighted and the case laws. What I want to highlight here it is the restitution of the concept of conjugal rights. Personal laws, conjugal rights which are available to wife as well as husband. And there are many cases where the Supreme Court clearly said conjugal rights means cohabitation entitled for each other's society. A case came up before the Supreme Court. The question arises whether the conjugal rights of a husband includes demanding a child from a wife. Supreme Court says no. Supreme Court says conjugal rights does not include a right of a husband to demand a child from wife. Because support Article 21, reproductive rights, it is her choice, as the word is said. Reproductive rights means say yes or no to a child, to a sex, or maybe your other within the institution of marriage. One side being a feminist to protect Article 21 of women, we always see reproductive rights should be protected, should be safeguarded. It's an interest of women. But when it comes to the institution of marriage, we have to maintain a balance between the reproductive rights of a wife and as well as the conjugal rights of husband. I think this is a grey area where don't support only rights, the reproductive rights of wife, where we need to give consideration to the desires of a husband to have a child instead of going for a divorce, going for a dissolution of the marriage. Try to support, protect the interest of a husband who is asking for, who has a desire to have a child within the institution of the marriage, a marriage relationship between husband and wife. And apart from that, this is a recent 2022 case, Nagpur bench of Bombay High Court of Judicature, which is related to again reproductive rights. But here I just wanted to highlight, I don't know whether it is fit in my presentation or not, Article 16 of Convention on Elimination of all sort of discrimination against women, whether married, single, girl, what is termed women. Right to marriage and a right to family. From an Indian perspective, the cultural background or the societal background what we have, when we say marriage, it is not just a relationship between husband and wife. The family members are also involved. When a wife says no child, I don't want to go with that, with respect to that. The desires of the husband cannot be protected as we have already pointed out, but the family members' desires, especially the grandparents. Right? So this we need to address. The right to family or the right to marriage. Don't think just from the perspective of the wife, but think from the perspective of husband also. Because we have so many instruments, we have so many laws to protect only the interest of a woman here, especially the wife within the institution of marriage. Because as I believe, my personal belief here it is, when we say marriage, it is not just a one person, it is not as, as a one-man show. It is a coordination, cohabitation between husband and wife. And apart from that, there is a huge role to be played by the family members. So thinking from all the perspective, when we say reproductive rights, I think right now we always say it is exclusive rights of women. When it comes to reproductive rights, can I use the word reproductive choice? Where a husband can also has a say, no, even I want a child within the institution of marriage. It should be highlighted or it should be protected. So the last suggestions, it is maintain a balance between the conjugal rights of a husband with the reproductive rights of a woman. That is the grey area we need to research or highlight. So the last, I don't know how many of you are aware with this particular great personality. We speak so many things when we come near the mic or a dais. Actually, the ultimate truth or the actual practical aspects. Is it so easy for a working woman or a married woman to exercise a reproductive rights at the cost of our children, at the cost of our family, at the cost of our career? Okay, so I think I need not to throw any light on this particular image. That's because we say so many things, everything it is there in black and white. When it comes to actual implementation, do we really accept reproductive rights in a fair manner? Do we really encouraging empowerment of women? All those things we need to think on these concepts. Thank you. I thank CS Patil Patil sir, Kilpar, Valarmati madam, Sapna ma for this opportunity. Thank you.
Thank you, ma'am. I would now like to invite our second speaker for the same topic, Dr. Advocate Girish Kumar R, High Court of Karnataka, and panel discussion, panel counsel for Rajiv Gandhi University of Health Sciences, Bangalore.
Respected Chairman Kilpar, Dean, School of Law, Christ Dean University, Professor Valarmati ma'am, Professor Irani ma'am, and other co-speakers. My deliberation will be on this legal perspectives on reproductive rights and medical termination of pregnancy, a balancing approach. See, I think so many of the co-speakers spoke about what are the reproductive rights. I am not going to deliberate upon those aspects. It is considered as a fundamental human rights which has been intrinsically linked to the individual's body autonomy. And this is one of the facets of Article 21, and right to make reproductive choices without undue interference, especially from the state, is a fundamental right that is being considered. And right to control one's own body free from discrimination, coercion and violence. Coming to the definition of this reproductive rights, WHO has given one definition. See, what I want to stress upon this definition is that it says that basic right of all couples and individuals to decide freely and responsibly. One, the number. Second, the spacing. Third, the timing of their children. And to have information and means to do so, and the right to attain the highest standards of sexual and reproductive health. What I mean to stress upon in this particular definition is that this basic right, it uses the word basic right of all couples. Couples include even the men. So in that sense, it not only includes the maternal rights, it also includes the paternal rights. Before I go into the key provisions of this MTP Act, see, when you see the constitutional provisions, I think so, the constitutional provisions that is being provided under our constitution is that Article 21 is relevant, and the reproductive rights have been defined under this particular article, and right to dignity, personal liberty, right to privacy, then bodily autonomy and integrity. These are all the different facets that is being described under Article 21 in respect of this reproductive right. Before the MTP era, if you go back to this pre-MTP era, see, there was where this MTP Act legalizes the abortion. Before the MTP era, prior to this 1971 Act, the legal landscape governing the abortion in India was dictated solely on the provisions that were contemplated under Indian Penal Code, Section 312 to 318. And this restrictive legal environment, however, did not eliminate abortions. And these abortions used to take place undercover, underground, all these things used to happen. And that is where the Department of Health and Family Welfare, Government of India, thought that we need to have some sort of regulations in respect of these abortions. And that is where this Shantilal committee was formed by the government, and the Shantilal committee recommended that we need to have a separate legislation, and in this backdrop the provisions, the MTP Act was enacted. And when you see the objectives, initially when the Act was enacted in the year 1972, which came into force in the year 71, the Act is, but it came into force in the year 1972. If you see the main objectives, one is the reduction of maternal morbidity and mortality, legal clarity for providers. What is this legal clarity for providers? See, doctors were scared to abort the fetus for the very reason that they do come under the purview of the provisions that is being contemplated under the Indian Penal Code, and that is the reason why there was some sort of a legal clarity by enactment of this particular act, and it decriminalized under specific conditions, and safeguarding the woman's health, because abortions used to take place at an unknown place and by an unknown persons. So because of this, it used to cause lot of maternal morbidity and maternal mortality, and because of these reasons the government thought that we need to have a special legislation, and this was the one which was provided to us. And 1971 Act provided certain gestational limits. See, in 1971 Act, 12 weeks of gestation was based on the opinion of one RMP. Yes, you can abort the pregnancy. And 12 weeks to 20 weeks, opinions from 2 registered medical practitioners were required. And what were the grounds for termination? One was that risk to the life of pregnant woman, first. Second, risk of grave injury to her physical or mental health. Then third one was substantial risk to the child if born would suffer from serious abnormalities. So these were the grounds that, or specific conditions under which a pregnancy could be terminated between 12 to 20 weeks. And when you see the drawbacks, that is before amendment, see, 1971 Act did not conceptualize the abortion as a fundamental right. It was more towards the provider-centric. It focused on a provider-centric, on creating an exceptions for the doctors within the criminal framework of Indian Penal Code. And access was mediated through the good faith opinion of the registered medical practitioners based on legally sanctioned grounds. So they have to give an opinion, and your right to abort was based on these opinion of these registered medical practitioners. And the Act did not permit abortion solely upon the request of the woman or explicitly as a family planning method. And this laid on a groundwork for future debates on women's autonomy versus medical authority. And in this context, I'll tell you, the MTP Act was amended twice, and what is important is the 2021 amendment. What were the compelling circumstances in which this MTP Act was amended? Let us understand. See, this is the first case, fetus with Down syndrome. Are you aware of the Down syndrome? Yes. This is one congenital disease or a genetic disorder where it's a chromosomal disorder which leads to mental retardation. See, in 2017, a family was denied permission to abort a fetus having Down syndrome, and the fetus gestation age was around 26 weeks, because the 20th week mark had been crossed, because 1971 Act prescribed that 12 to 20 weeks to registered medical practitioner's opinion, based on that you could abort the fetus. Since it crossed the 20th week mark, the family who had already had a child, and that child, the first child, is a special child, and she had also suffered some sort of genetic disorder, and this was the ground that was taken by the family, and they approached the registered medical practitioners, and very unfortunate that they did not come forward to abort the pregnancy for the reasons that because of the MTP Act and other provisions that was provided under the Indian Penal Code. And the denial of termination of pregnancy caused additional distress to the family and generated mistrust in the judicial system itself. And a well-formulated act, that is MTP Act, initially ahead of its time, had not kept with the pace of the technology and needed to be revised. This was one of the compelling circumstances which made the legislature think that yes, we need to have some amendments that should be brought into the MTP Act. The second case was this fetus with abnormal cerebral ventricles. See, abnormal cerebral ventricles, in this case there was enlargement of the brain ventricles, there was a collection of the fluids, and coupled with a history of 2 miscarriages, sought a consultation at the consultation with the doctor, and the gestation period of the fetus was around 19 weeks, but still the obstetrician did not come forward to abort the pregnancy. This is another case, and the baby was born with this sort of anomaly. Then the third case, genetic disorders detected in third trimesters. See, there are a lot of genetic disorders that cannot be detected in the first and second trimester of the pregnancy. So that could be detected in the third trimester. One such example is this primary microcephaly. The head of the baby will be very small. And another one is lissencephaly. See, as you know that our brain has got this ridges and grooves. You know why these ridges and grooves have been formed in the brain? The God has given that. The reason is that to increase the surface area of the brain. To increase the surface area of the brain, we have this ridges and grooves where you could store your memory in those parts. Whereas in lissencephaly case, this is a medical condition where the brain will be smooth. See, this is also one of the genetic disorder. So these could be detected in the third trimester of the pregnancy. And the act that was prevailing, it will not prevent beyond 20 weeks that you could abort the pregnancy. See the drawbacks of this act. So, because of these compelling circumstances and other circumstances, I'll tell you, the legislature, by its wisdom, thought that we need to amend this particular act, and this was the amendment, and significant changes have been brought in this amended provisions. The one is that it increased the enhanced gestational limitations. See, upper limit for termination was increased from 20 weeks to 24 weeks for special categories. Then revised medical opinion of only one registered medical practitioners were required for termination up to 20 weeks, and 2 registered medical practitioners for 20 to 24 weeks. Exception was provided for substantial fetal abnormalities, wherein it removes the upper gestational limits of even 24 weeks also. So what this act enables us is that even beyond 24 weeks, yes, if there is substantial fetal abnormalities, you could abort the pregnancy. Then establishment of this medical boards and inclusion of unmarried women. Yes. The earlier act contained married woman or her husband. That was the specific words that was used. And because of the intervention of the Honorable Supreme Court, yes, this word has been substituted by any woman and her partner. So this is one of the important amendments that was brought in. And this legally, what it makes is that it legally recognizes the right of unmarried women to access abortion on this ground.
To change in the law if you feel that law is not protecting the rights of the stakeholders here. I think you can delay the lunch a little bit longer. With that note, the topic that I'm going to speak about is right to personhood under the Surrogacy Regulation Act of 2021, issues and challenges. Now, in the morning, Professor Jogarao was talking about few celebrities who have opted for surrogacy, and he said that before the law is passed, quickly they went for surrogacy and they got blessed with children. Now, if you look at these pictures, do you feel because of them being single or because of them being of a different sexual orientation, you feel that they can't be good parents? Is that the impression that we get when we say that a mother has to be there? There has to be a father and a mother. There has to be a male and a female. If you have good parents. So the paper that I've worked on is basically looking at this aspect. When we say right to personhood, should we decide or should law be deciding who can be a good parent? And should the law then say, okay, if you have these criteria, if you satisfy these criteria, only then we allow you to go for surrogacy. So just an overview, surrogacy is defined in this legislation in section 2 ZD, wherein they are saying that we call it as renting the womb. So a woman is allowing her womb to be used by an intended couple or an intended woman to bear their child. And once the child is born, this child is handed over to the commissioning parents. The types that the legislation considers is altruistic and commercial surrogacy, under which altruistic is legal, commercial is prohibited under the law. There are two other kinds, traditional surrogacy and gestational surrogacy, based on how that fetus is created. And if you look at the law, they are for gestational surrogacy because of the cases that have preceded before this law came into existence. I'm sure you would have heard of this baby Maji case, wherein there is this Japanese couple, they come to India and they go for surrogacy, they are blessed with a baby girl, but before they could proceed with it, there is some issue between the husband and the wife, and the wife says, I don't want this baby. Now the surrogate mother has, baby has been implanted in her womb, the baby is developing, and now the couple, especially the wife, decides that I don't want this baby. Now what do you do with that child? The parents or the couple who decided to go for or bring this child to this world now says, one of them says, we don't want this child. What do we do with that child? Right? What is the fate of that child? Later on, the custody was given to the father and the grandmother. So the father and the grandmother, they took care of the child and back to Japan. But that brought out the intricacies and legal issues that this surrogacy brings in with it. So there, the main issue that we were talking about is, if we go for traditional surrogacy, wherein you are taking the egg from the surrogate mother, and only the sperm is given by the biological father, there is an attachment that the surrogate mother may develop, and which later on would lead to the mother refusing to hand over the child and saying, I bore this child 9 months in my womb, I have right over this particular child, I should be bringing up that child. So keeping all that in mind, we said we will permit gestational surrogacy, wherein the womb is only a place where the baby will be growing. But there are no DNAs, there is no connection between the surrogate mother and the child. Now, interesting provisions that I've taken into consideration here is the definition given for intending couple and intending woman. So the legislation provides for an eligibility criteria. And first one is, for an intended couple, they have to be married. They have to be married, and due to infertility, they are not able to get a child. Or if they have a child, that child is disabled or is suffering from some illness due to which the child has a risk of
death. In those cases, they can go for surrogacy. But the issue with that is, first of all, when you're saying married couple, you are keeping aside people who are in a living relationship. You are keeping aside, gays, the LGBT community, and you are saying only a man and a woman should be allowed to go for surrogacy. Now, that is an issue because if you look at the rights that the judiciary has recognized, there is right to personhood, there are rights of the LGBT community, there are recognition of living relationships. You will see that on the one side we are talking about Article 14, right to equality, there should not be any form of discrimination based on these grounds. But on the other hand, this particular law itself is not recognizing that equal status. So why there was a need for such a law was because before 2015, we didn't have a specific law for surrogacy. And a lot of women who were from an economically backward society, they were offered this proposition, if I may say, that there is this foreign couple who are not able to have a child. This foreign couple in whose jurisdiction surrogacy and such practices are not permitted, they are ready to give you a few dollars if you bear their child. And that's where it started, so much so that I'm sure you would have heard of this place called Anand in Gujarat, which is known as the hub of surrogacy. And I'm sure you'll find a lot of interviews wherein they have spoken to these women who are, if you look at the way they are living, it's a very, very sad scenario. And why they are living in that way, in spite of being so much by the, paid so much by the commissioning parent, is because of the role of the middlemen and the healthcare sector, especially the ART clinics. ART clinics, artificial reproduction technology clinics, wherein they meet these middlemen and with their help identify who are those women who are ready to bear this child and are in need of money. And they make use of that vulnerability of this group to say, okay, see, there is this foreign couple, they pay you in dollars if you could bear their child. So they started exploiting this, and the position of the women, the surrogate mothers, and the child that was born, especially scenarios wherein the commissioned parents later on decide, okay, we don't want to go ahead with it. So that made the state realize that it's high time we regulate this particular system and have a law in place so that the surrogate mothers are protected, their interests, they are not exploited, and that's why all this discussion has come up. Now the key questions that I've addressed here is, we have looked at the provisions of the Surrogacy Regulation Act, how the Act affects intended parents, surrogate mothers and the child. Does the Act protect the rights or restrict freedoms? And what are the legal and ethical implications? So to find answers to these questions, there are mainly few rights that I've looked at from the law's point of view as well as from the judiciary's point of view. First is the right to be a parent. Now that is recognized as a human right. So from morning you've been listening to presentations, wonderful presentations, where they're talking about the autonomy of the woman, the privacy that they should be given in deciding whether they should or should not have a child. But if they decide to have a child, if they want to have a child, should law be stopping them from using these technologies? And who should be permitted to exercise this right of personhood is what I've looked at. Then right to privacy and bodily autonomy already discussed. Right of LGBT plus persons. Now this also I'm sure you all know that they are recognized, right? But if they should not be discriminated based on their sexual orientation, this law somewhere is bringing in that discrimination. So the point that I'm trying to make in this paper is that on the one hand, we're talking about right to equality. We are saying the transgenders, the LGBT community, married and unmarried persons, everyone should be treated equally. But on the other hand, you're bringing up a law wherein that discrimination is very, very obvious. Then living relationships. Now, I'm sure you know that the domestic Violence Act. They do recognize domestic violence committed in case of a live-in relationship. So it's not that it is not a recognized setup, but then they are not allowed to go for surrogacy mainly because they don't come in the category of married persons. So intended couple, the definition, the eligibility itself says that they should be married. They do not have children. If they have a child, then that child should be disabled or might be suffering from illness. Now there also the issue is, if you are permitting a married couple who has a disabled child to get a child through surrogacy, is it possible that that disabled child might be sidelined? That the resources till now which was given to this child with special needs is now being diverted towards this surrogate child, and the resources, the recognition that the other child gets, that might get affected. Now this is one of the debates that are going on as far as this requirement of having a child for a married couple with disabilities is concerned. Just to give an overview, the law permits only altruistic surrogacy. That is, even in altruistic surrogacy, they have given the definition of who can be a surrogate mother. And they say that this mother should be related to the couple, or she should be related to the intended woman. So if someone, the morning sir was also talking about, that if someone wants to voluntarily, allow their womb to be used, the law does not permit them for going ahead. Why? Because obviously the first impression is, if someone unrelated is going and allowing their womb to be used, then there might be some monetary benefit that they are getting. That is the first impression with which such cases are looked into. It prohibits commercial surrogacy, which actually is a good thing because they have now ensured that the process is a little more streamlined. There are certain eligibility criteria that have been provided. But the fear here is that it might lead to what we call this as black marketing or illegal surrogacy. So now you are somewhere, I wouldn't say promoting, but giving an incentive for an illegal industry of surrogacy to come up, because commercial surrogacy legally is not recognized. Then, as I said, eligibility of Indian couples and surrogate mother, the way they have given it, the age group that they have provided. So women should be 23 to 50 and men should be 25 to 55. Now, what is the basis for that particular age criteria? Is there any medical justification that only they can be good parents, or after that particular age they cannot be in a position to take care of the child? Then the age group of surrogate mothers, 35 to 45 years. The mother should have been married at least sometime, should not be an unmarried person. Okay, so these eligibility criteria is something that we should look into. Then all these categories of persons. Out of these, foreigners, now the data shows that before this law came into existence, close to 2.5 billion was the value of this industry. 2012, 2.5 billion was the value of this industry. And of the surrogacies that were done in India, 50% was for foreign couples. So yes, on the one hand, there is exploitation, there is misuse. But on the other hand, if the woman, if the family, if she is in a position to go for surrogacy, it has helped women to actually, come out of that economically backward situation. But then again, we have to see whether it is possible to ensure that the exploitation does not override the benefit that it gives. And provides for mandatory, the medical boards, national and state surrogacy boards. Now these boards are definitely going to certify whether you are eligible to go for surrogacy. And if you don't have that eligibility, you are not permitted to take this method for getting a child. They say if you're not eligible, then you might as well go for adoption. But then that's where the next issue comes in. Under our laws, a male cannot adopt a female child. So if a gay couple or a widower wants to adopt a child or have a child, they cannot under the law. So the impact on intending parents, reduce accessibility, because now there's a lot of procedure that they have to follow. If they don't qualify, they cannot go for surrogacy. lack of options for non-traditional families. So here we're talking about living relationships for the LGBT community. From choice-based to need-based. So earlier, if let's say they have, I'm sure you saw the pictures, right? If they already have 2 children and they want to have one more child, but the husband or the wife is not, in that particular health to have another child, they had a choice of going for surrogacy. But now with this law, that choice has been taken. Then there would be a sharp decline in cross-border surrogacy because foreigners are not permitted to go for surrogacy in India. Impact on surrogate mothers. Now these are additional areas that maybe that we can think about. It was earlier income generating option, but now it has become unpaid labor because we are saying commercial surrogacy is not permitted. The only thing that these women can claim if they agree to be a surrogate mother is to have the expenses incurred. Only that expense they can claim. Then no adequate compensation for time, effort and the risk that they are taking. Yes, law provides for an insurance cover of 36 months, but that insurance cover does not take into consideration the mental health related risk that the surrogate mother may go through. There is better protection on paper, but it is reduced to autonomy in practice. ART clinics, now if 2 couples want to go for a child, there is a procedure, there's a lot of licensing requirements, which is good because then illegal surrogacy is getting addressed. But then it means there's a lot of compliance requirement that we need to have. Then a risk of underground or illegal surrogacy market and fertility tourism, that will be reduced to a great extent. Then the ethical and moral issues. The ethical issue is, should you think of a child as a commodity? Because when you're saying surrogacy, at least when it was commercial surrogacy, it was the child, you're paying money to get a child. So should child be considered as a commodity? Then is banning commercial surrogacy truly protective or paternalistic? There is a debate between empowerment versus exploitation, especially when there is forced labor. By forced labor, what we mean is that the women deciding whether they should go for surrogacy and the amount that they are compensated for going through this process. Then women's autonomy versus state control over reproduction, wherein the right to privacy comes in. And when we say altruism, how practical it would be. What we look at this particular legislation is it is too restrictive. It violates reproductive autonomy. There are exclusion of many legitimate family structures. There is poor implementation at ground level, and the legal ambiguities with respect to citizenship of the child, parental rights, protection of surrogate mothers. That also is a challenge. So the suggestions is we should not outrightly ban commercial surrogacy, but rather maybe come up with a framework whereby it is regulated to ensure that the surrogate mother as well as the commissioning parents, their rights are protected. Then inclusive, if you're saying that all these communities are equal before the law, should not be discriminated based on these parameters. In the law, this particular law should also recognize their right to be parents. And ensuring surrogate mothers informed consent and fair compensation, and there has to be continuous monitoring and policy update. So to conclude, we should shift from commercialization to regulation with the intention to protect. It tries to restrict the freedom that people could enjoy. A more balanced and inclusive approach is needed, and a right-based, ethical and regulated framework is the need of it. With that, I end my presentation. Thank you so much.
The dais is now open for questions to the presenters.
Anybody has any question?
I would now like to invite Dr. C.S. Patil to felicitate the resource persons. I would now like to invite Dr. C.S. Patil, Chairman of Karnataka Institute of Law and Parliamentary Resource, Kilpur, to present a certificate of appreciation to the resource persons. Dr. Anuja S., Associate Professor, Manipal Law School, Bengaluru. Advocate Girish Kumar R., High Court of Karnataka, Panel Counsel for Rajiv Gandhi University. Professor Indrani K.S., Principal of Bishop Cotton Women's Christian Law College, Bengaluru. Dr. Gayatri Bai, Assistant Professor, BMS Law College, Bengaluru. Dr. Deepthi Susan Thomas, Assistant Professor, Christ Academy of Law, Bengaluru. Thank you, sir. I would like to once again thank all our speakers for taking time out of their busy schedules and for imparting their wisdom to all those present here today. To say that it was a valuable learning experience would still be an undercredit for all that was said in the session. Thank you to all the dignitaries, guests and the participants who attended this session. We hope there was as many takeaways as anticipated. Before we begin with the presentations of the submitted papers, we will be dispersing for lunch break, and I request everyone to reassemble the presenters by 2:20 for lunch break, as the presentations will begin at 2:30. I request you all to proceed to the gourmet extension in the central block for your lunch, and there will be an usher escorting each one of you. Thank you all for your patience.
But still, this was not felicitated in every other industry. Only few of them encouraged this, and most of the other women were not allowed. Though under the Maternity Benefit Act of 1961, they said only 2 or 3 areas, here they include